Good morning and welcome to the Supreme Court of the United Kingdom. Today we are hearing on the second day an appeal by the minor O against the Secretary of State for the Home Department, and we are in the submissions on behalf of the Secretary of State from Sir James Eadie. Sir James.
My lords, my ladies, good morning. I wanted to finish off, hopefully the submissions that I threatened you with 4 of them yesterday. I think there are only going to be 2. And I wanted to finish off the point about unison by making the submission that unison properly viewed is a principle of exceptionality, whether approached through the constitutional angle or whether approached through JCWI, rather than a principle of general application across all fee schemes enabled by Parliament. Its facts and its context involves truly fundamental or constitutional rights of a kind that would engage the principle of legality, which, as you know, is confined in all the descriptions of it, including the font of the description, namely Lord Hoffman in Sims at page 1704 in your bundles, to overriding, I underline the word, overriding fundamental or constitutional rights. And that overriding deserves emphasis, and it received the emphasis it deserves, we respectfully submit, in the Court of Appeal's judgment in the Dolan case, at paragraphs 66 to 67. So you can't just show that a conventional constitutional right is engaged, you have to show that it would be overridden. That is in the authorities at page 1542. So that's what I wanted to say about unison. Can I turn then finally, before I come to statelessness briefly, to the JCWI principle and take the points that my learned friend made there directly, if I may, on that case. And I make 2 initial points about JCWI. The first of them is that, as Lord Reid was at pains to point out, it wasn't necessary to go there in unison. One can have a sterile or not debate around whether or not that makes it obiter, but it was not necessary to go there because it didn't add anything to the first ground. So it was essentially treating the principle as it were, engaged because of the particular factors that were in play. And we do therefore submit that Lord Justice David Richards below was right to note, as he did in paragraph 55 of the Court of Appeal's judgment in this case below, electronic 131, that it was, quote, unnecessary to consider the second ground, and Lord Reid only touched on it. We respectfully submit that's a correct conclusion. But secondly, by way of initial point, it was not, the JCWI principle was not treated or put by Lord Reid in unison as being some new point of general application to all fee schemes. It was not put on the basis that if you establish in effect a fee regime associated with rights that Parliament has conferred only on application, the approach hereafter, or after unison, was to be one in which reasonable affordability was in effect imported. The reasoning in unison and the noting of the JCWI principle was sufficient unto the day, and not to be taken more generally as beyond the day. But the key point in all of this in relation to JCWI, after those 2 initial points are noted, is that the correct analysis of the JCWI principle is that it is at foundation simply a principle of statutory interpretation. What was Parliament's intention in enabling the scheme of secondary legislation in the particular legislative context that the court is considering? Or to put the same point another way, is the scheme made by the secondary legislation consistent with the enabling will of Parliament? And what JCWI is really about is the possibility of unintended or unconsidered consequences of the exercise of an enabling power. And once that is correctly understood, as it evidently was by the Court of Appeal below in this case, then we do respectfully submit, if you just turn it up if you would, that paragraphs 59 to 63 of Lord Justice David Richards's judgment, 133 in the electronic, those 4 paragraphs are both, I may respectfully so submit, insightful and correct. Can I just invite you to remind yourselves of that approach and those paragraphs? The key point of principle being the one at paragraph 61. And you will see, if you just track forward by way of note, that Lord Justice Singh in effect adopted exactly the same approach of principle. The JCWI note in particular, although the section of relevance really embraces the whole of his short additional judgments, see in particular paragraph 122 at the bottom of EF 147. And once the nature of the JCWI principle is appreciated, a number of things follow, we submit. But firstly, it follows, as they also correctly analysed in the Court of Appeal below, that the principle is not confined to different legislative regimes. And that is because, as a question of statutory interpretation, or an aid to statutory interpretation, it is necessary to examine the scheme of the relevant legislative provisions as a whole. That's the first thing that follows. The second thing that follows is that the fact that you're dealing with different legislative regimes, in effect colliding, may well have real significance, but in the application of the principle. And it may well have significance in the application of the principle for the reasons that Lord Justice David Richards gives. In paragraph 61 of page 133. In essence, it may well be less likely that Parliament actually thought about or intended the consequence if the regimes are different. But of course, the flip side of that point about application of the principle is that when the enabling power is in the same legislative regime, it is highly likely that Parliament did think about the point. And there may well be very little scope for force to be given to the JCWI principle or approach. The final thing that follows from an appreciation of this as an approach and a principle is this: there may well be a greater need to examine with real care whether Parliament truly intended in enabling a secondary legislation fee scheme to be set up in one context to permit the undermining of rights in another very different context. But of course, that is an interpretive question or approach whose engine is the bare difference of context, if that isn't too opaque a point. The engine for that approach is not the high-powered one of overriding a fundamental or a constitutional right. Put the same point a slightly different way, the force of the basing principle is different. And there is a question, perhaps for another day, about whether in those circumstances the consequence in a true JCWI context is or should be the same as the principle of legality. In other words, requirement for express words or necessary implication. as opposed to simply being a question of interpretation to be resolved in the usual way. And there may well be a strong principle case for saying that real care is needed about the introduction of what is in effect the principle of legality, which has always been linked to the overriding of fundamental rights, into that very different context. And that's obviously important because the discovery of statutory purpose, if you're looking at it through a Padfield or a Fewings lens, is the ascertainment of legislative intent without the skewing that the principle of legality brings to that exercise, a skewing designed to reflect the improbability of Parliament having intended to override fundamental rights. So there is a real concern of principle about whether or not the exercise of statutory interpretation is to be and should be skewed in that way, rather than simply approaching it, as it were, on a level playing field, interpreting the scheme of legislation that Parliament has enacted using all the usual canons. I put down the marker only, and it's only really a flag marker, because my fundamental submission, as you appreciate, is that this court does not need to grapple with that set of questions in the present context. And that is because this fees regime, the one that confronts you, is in the very regime creating the right, clearly and expressly deals with application and all associated things to do with fees as a condition to the right arising, and contains expressly in the primary all of the detailed scheme of control which I went through yesterday. Express provisions enabling the very conditions which govern the exercise of the right, including specific conditions which might very well make, and plainly in the contemplation of Parliament might very well make, the fee regime unaffordable to some. So an express provision in primary legislation and the enabling provisions about the ability to set fees in excess of cost, listing the exclusive factors that are to be taken into account in the design of the secondary legislative scheme in section 68(9) of the 2014 Act, permitting maxima to be set, permitting decisions to be made about exemption or waiver or not.
But there would still always be the question whether, however plain the words, Parliament could set a fee which was totally unreasonable on any basis. Which may say we don't have
there would. I think there would, and it's to some extent back to the point that you raised with me yesterday about whether the thing would be different, or maybe Lady Rose raised it, about whether the thing would be different if we didn't have the 2014 Act. We just had sections 41 and 42. The £1 million question, which was the interesting question of principle that they considered in Williams and other cases earlier, is answered by the specific and express legislative scheme that they have set up in the primary here, which permits maxima.
It isn't engaged as such, but it's simply the elephant in the room.
Well, it's simply the elephant in the room, but it permits the maximum levels to be set, as it were, stopping the open-ended, can you set a fee which would be entirely unaffordable for all question.
But do you say that the resolution procedure, if properly followed, and I'm assuming there's no question of regularity with which the courts might possibly be concerned, is then conclusive evidence as to the lawfulness of the amount?
My lady, I do almost submit that. What I submit is that you've got a level of detail in the primary legislation which is only consistent with the idea that Parliament well appreciated, A, that there would be a limit on the amount of fees that could be charged, but B, that that limit could be set at a level which wasn't necessarily affordable to all. That's, I think, how I put it. But I think the answer to my lady's question is yes, but I just put it in that slightly different way. Lady Rose.
That is the absolute question which one hopes one never has to face, in a way. But it's important to remember that it is there.
My lady, yes, I accept that. These are always questions of Well, there are always questions ultimately of how you approach the enabling scheme that Parliament has set up.
Or more fundamental, yeah. Thank you.
Lady Rose, yes, sorry.
Might it be said against you that the fee charging power in the original 1981 Act was directed at the rights conferred by that Act, the rights to citizenship? Whereas we know from the extensive fee order and regulation that the powers conferred in the 2014 Act relate to an enormous range of different kinds of applications, tier, whatever, immigration status, premium services, consular functions. And in all those sorts of things, one can quite see that they don't at all engage rights of this kind. But might it be said that the generality now and the huge range of different sorts of applications that are covered by this fee charging regime might mean that Parliament did not have in mind that amongst that huge range, there were these perhaps few applications that were actually of rights conferred by the statute and not those sorts of more, well, if you want it, you have to pay for it, but you're not entitled to it, sort of application.
Lady, that argument could be run. I suspect it's part of the argument my own friend seeks to advance, not quite in that way. I think my answer to it is to point to the fact that Parliament will have been well aware. Of course, it's covering a range in the 2014 Act, but it will be well aware that it's covering all of these situations, including those rights that are conferred under the BNA as rights. So my first answer, I think, is to point to the fact that Parliament was well aware that it was covering the field, but it was also well aware, necessarily, that it was covering this part of the field. The second thing, perhaps, to be said in relation to that question is that it does, to some extent at least, resurrect the extremely problematic distinction that my learned friend appeared to be driven to in his oral submissions yesterday, between, on the one hand, a right, and on the other hand, the gateway to the exercise of a discretion by way of a right. And that is intensely problematic for all the reasons that I dealt with yesterday, and I don't repeat. So although I see that one could say, well, now it covers an enormously broad canvas, can't we approach these things in a slightly different way, and can it really be said that Parliament contemplated all this? But I think my answer to that is, it's a broad canvas, but the Parliament should not be taken to be unaware that the broad canvas is covered by all of the myriad different brushstrokes which make up the picture. That's the first and principled answer, and the second one is problematic right versus right to apply for the exercise of a discretion. So my ultimate submission in relation to all of, my Lord, sorry, was Lord Stevens asking a question?
Well, I was just coming back to the distinction between a constitutional and fundamental right and a statutory right. And you're accepting, as I understand it, that the principle of legality applies to a statutory right by virtue of the fact that if you set a fee of £1 million, you would be preventing the exercise of that right. You'd be overriding it. But you don't use as a test affordability. I was wondering what test you do use. The situation prior to 2014 was it was open to you to set a fee of £1 million if you had so wished. It might have been irrational, or there might be some other test. I don't know. I was just wondering what test you apply.
Well, my Lord, can I make clear that I'm not accepting that any statutory right, by virtue of being a statutory right, it would attract the principle of legality. The principle of legality is confined, for the very principal reasons that were explored and analysed in Whittam and Lightfoot and all that line of cases, to those rights which have that particular fundamental and constitutional character. So I'm not accepting as a proposition that any statutory right, if overridden in that way, would attract that principle. But you asked me the question, what would be the nature of the control, or what would be the nature of the test in circumstances in which we did not have that which we do now have, namely primary legislative control requiring the setting of maxima, which necessarily impose some form of ceiling which Parliament would be content with. I suppose in theory that would leave open the possibility of the maxima being £1 million in the order, but then Parliament would have to have approved that under the affirmative resolution procedure. Prior to that act, which is not the situation we're currently dealing with, there was an interesting question about the £1 million fee, and you've seen in Williams that I conceded, no doubt on intensely pragmatic grounds, that £1 million would not be a sensible fee that anyone could set. And I suspect that the answer to the question at that stage, what is the legal basis for that concession, other than self-service, for the purpose of the argument that I was seeking to deploy, the answer would be the principles of public law. And they're having to be perhaps implicit through those principles in the scheme, controls through rationality or through a Padfield type approach that would actually create some form of link of sense between the setting of the level of the fee and the service which was being provided, particularly in circumstances where in the early days and before 2004, the real and true controlling principle, I suspect, would have been that it's implicit, unless there is some very clear provision otherwise in a fee setting scheme that Parliament sets up, that it will be linked to cost. That's why 2004 you have primary legislation permitting you to do something else. So there are various ways in which the £1 million problem can be avoided on a principled and sensible basis. But as I emphasised, that is not the situation, or not in anything like the same form, the situation that you need to trouble about now, because we've got the 2014 Act. So I hope that goes somewhere close to answering my Lord's question on that front. The principles of public law and or those principles of statutory interpretation is the answer to the £1 million question. Sorry, Lady Rose.
Yes, just to add a comment on that. I mean, that in itself is part of the constitutional principle of no taxation without primary legislation, that is why fees generally are not supposed to exceed the cost of providing the service, because otherwise it amounts to secondary legislation imposing a tax.
Yes, I'm sure my lady is right. That's the basis on which that line of case law, I think, was decided, wasn't it? You are effectively doing that. My Lord Briggs, yes.
James, you kindly said yesterday you'd look into the question of whether the grant or withholding of registration of citizenship to someone who was settled here by virtue of 10 years almost continuous residence from birth controlled that person's right to vote in general elections.
My Lord, yes, I did. And I'm sorry, I was going to trouble wanting to come in before I answer that question.
Yeah, well, that was, if I could, it may or may not help for me to say that I was going to cover that in reply. And there's a fairly long passage in our skeleton argument in the Administrative Court of First Instance, which gives the statutory references and background material. The answer is yes. But the answer is citizenship confers the right to vote. It's one of the action. It's one of the rights, the bundle of rights that goes with citizenship.
My Lord, I'm sure there's going to be no dispute about that, if that's the short proposition. We looked at it overnight just to make sure that my Lord doesn't feel we're ignoring the question. The answer, as we understand it, is that the criteria for the eligibility to vote in parliamentary elections is contained in Section 1 of the Representation of the People Act 1983. To be eligible to vote, a person must satisfy 4 conditions. 1, on the electoral roll for the relevant constituency, Section 1(1)(a). 2, not legally incapable of voting, Section 1(1)(b). 3, either a Commonwealth citizen or a citizen of the Republic of Ireland. And 4, aged 18 or over at the date of the election. So British citizens, yes, sorry.
Well, those apply to Westminster elections and also to devolved elections, but they certainly don't apply to the referendum in Scotland, and they may not apply to potential future referendums in Ireland. Because the move in the proposed draft Bill of Rights for Northern Ireland is a reduction in the voting age to 16.
Right. Well, my lord, somebody's I haven't sought to cover everything. I was just to see whether there was a link, at least in relation to our general elections, and to describe that system, if I may. I fully appreciate there were different provisions that govern the conditions for voting in relation to the EU Parliament, in relation to referenda within the United Kingdom in various parts and in various forms that we know have either happened or are threatened. But shall I just give you the position in relation to British parliamentary elections? That may be sufficient for the time being. So British citizens, British overseas territory citizens, British nationals overseas, British overseas citizens, all the various categories are Commonwealth citizens for the purpose of the RPA 1983. See sections 37 and 51(2)A of the British Nationality Act 1981. And on section 4 of the RPA 1983, a person is entitled to be registered on the electoral roll only if he's resident in the relevant constituency, not legally incapable of voting age, and so on.
But it follows then that the short answer to my question, I think, is therefore yes. That the grant or conferring of registration to someone who was settled here by virtue of 10 years residence from birth does carry with it the right to vote at general elections.
It does,
if that person wasn't already, for example, a Commonwealth citizen.
It does, but as you're aware, there isn't some magic to the 10-year period. You the application at any stage thereafter.
Yeah,
so one needs to look at section 1(4) and see how the conditions work through, and they're self-evident on the face of it. But you need to be a British citizen to vote.
Yeah.
I mean,
therefore,
the period, for example, in section 1(4) is only a period of 90 days, the absence provisions below the age of 10. But thereafter, when you hit 10, you can apply at any stage.
Oh, yes, I understand that.
Yeah.
I raise it only because it has been said, I think, that the right to vote is a fundamental or constitutional right, albeit not a common law right. Anyway, we're really concerned with the conferring of something which carries with it a statutory right to vote of a fundamental or constitutional type.
My lord, yes, and we're back to the discussion we had yesterday about the extent to which that's either directly in play or indirectly in play, and the difference between an application to do it and the right itself.
Yeah, sure.
But that's the position. So the short answer is yes, but you need to bear in mind that there isn't any magic, as it were, to doing it by a particular date.
I fully appreciate that.
Yeah.
In which case, yes. The right to register is not one which becomes statute barred, as I understand it.
No.
No.
It doesn't. And the right to apply for citizenship is a right that exists, as it were, forever.
Yes. Yes.
So one's got to factor in both of those temporal points, but subject to that, yes.
Yes, thank you.
I'm not sure I'm able to give you chapter and verse about how the possible referenda and all the other bits and pieces work, but if they're of interest, we can certainly expand on that.
I don't think it's necessary. All I was doing was saying that fairly major constitutional changes in the United Kingdom might be influenced by the ability to vote.
Well, my lord, I'm sure no one would dissent from that proposition. I was going to move to statelessness, unless there are other matters on which I could seek to assist on up till that point, as it were. Statelessness, then, very briefly. There are, we respectfully submit, at least some quite serious-looking procedural issues about statelessness and the way in which the amnesty intervention has been structured. Can I just give you what the position is procedurally? At first instance, there was a proposed intervention by amnesty, which was in effect limited to the composite submission that in enacting paragraph 3 of Schedule 2 to the BNA, Parliament intended to give effect to Article 1(2) of the 1961 Convention. Secondly, under that convention, no fee may be imposed and thirdly, that it followed that Parliament's choice of identical language of entitlement as between 1.3 and 1.4 of the BNA and paragraph 3 of Schedule 2 meant that no fee could be imposed, but there wasn't at least set at cost on the application to be registered under those provisions either. That was the case that they sought to mount in their intervention in the High Court. Mrs. Justice Yip refused Amnesty International's application on the basis that the appellants could make submissions on that issue if they wanted to. And they did before the administrative court. They made submissions corresponding to and going no further than the substance of that amnesty application which I've described. See, if you want references to the way in which the argument was put by the appellants at first instance, paragraphs 21 to 23 of their common issue skeleton at bundle page 329. The Secretary of State responded to that submission in her skeleton argument at first instance at paragraph 79, see page 426. Mr. Justice J considered and rejected the appellant's submissions as advanced on that issue at paragraph 77 of his judgment. See page 178. So far as the Court of Appeal was concerned, the appellants sought and were granted leave to go to the Court of Appeal against the judgment of Mr. Justice J on the basis that Williams could not stand in the light of unison. See paragraph 3 at page 231 in the electronic bundling. And consistently with that limited grant of permission, the appellants did not advance in the Court of Appeal any argument concerning stateless persons, the meaning and effect of the 1961 Convention on the domestic plane, or any read across to other provisions of the BNA. See their skeleton argument at page 259 in the electronic bundle. And as a result, the Secretary of State did not address any issues concerning statelessness in the Court of Appeal, and nor did the Court of Appeal in its judgment address the issue of statelessness in any way. Before this court, Amnesty now advances substantively and in summary 3 arguments. Firstly, that Article 1.2 of the 1961 Convention exhaustively lists the conditions which may be imposed, meaning that, as they put it, quote, the introduction of a further requirement to pay a fee in excess of cost of dealing with the application is incompatible with the 1961 Convention. That's essentially the argument that they sought to run and were refused leave to run at first instance, and that was picked up at first instance by the appellants, rejected by Mr. Justice J, and not renewed in any shape or form in the Court of Appeal. But Amnesty now also seeks to advance 2 further arguments, never run at any stage of these proceedings below. Firstly, that the regulations breach Article 13 of 1.3 of the 1961 Convention. And secondly, that the fees frustrate the object and purpose of the 1961 Convention in a general sense. And the second and third of those arguments, therefore, are completely new, were not raised below, were not argued about below, and are not the subject of any form of judgment at any stage of the proceedings below. Moreover, Amnesty do not frame their submissions before this court even in the same way as they tried to do below in their unsuccessful application to be intervened, namely as an aid to statutory interpretation. Instead, they seek to advance an entirely freestanding and independent challenge based on international legal provisions to the vagaries of the regulations. So we submit in those circumstances, there is a serious procedural problem with the court doing anything effectively with any of the submissions that Amnesty have sought to advance in their intervention. But lest it be thought that I'm trying to duck the substantive issue, can I just give you in the briefest summary what we say by answer, substantive answer to those provisions, even if you decide that it is competent to you to consider them, given the way in which they've been advanced and given the procedural history I've just outlined. Our first submission is that there was no error by the Court of Appeal in failing to consider points that were not raised before them. That requires no elaboration. Secondly, and even assuming that hurdle can be overcome, there is an initial point about the read across to other provisions of the BNA. And my submission in relation to that is that even if one could establish, as it were, incompatibility on the international plane, it's still got to be argued as a second and separate proposition that sections 1.3 and 1.4 of the BNA operate in precisely the same way and should be interpreted so as to preclude fees set above the level of cost. And we respectfully submit that there is no proper basis on which that second stage of the argument, even if the first one is correct, could work. It would in effect be allowing the tail to wag the dog. But thirdly, the points made on the various conventions are in any event untenable, we respectfully submit. Article 1 of the 1961 Convention, which you have in the Amnesty International Authorities, I think at page 483, may just be worth if you can chase that down on the screen. I'm giving you the number which I hope will take you there. You'll see that physically it's numbered page 480, but I hope if you put into your screens at the top 483, that will take you there, because every physical page is +3.
It does, Sir James.
So 483, you see Article 1, and the key bit I wanted to refer you to, for present purposes, is the provision in paragraph 1b of Article 1. In the manner prescribed by national law, are the words that I underline. And the key submission that we make, and the submission on the basis of which all of the submissions by Amnesty International in all of their varied forms founder, is that nothing in Article 1 of the 1961 Convention precludes the charging of fees. On the contrary, we say that is plainly envisaged by the wording I've invited you to underline. The conditions set out in Article 1.2 are substantive criteria relating to age, residence, criminal convictions, and statelessness, and so on. And as Article 1.1b makes clear, a contracting party may not refuse an application which meets the criteria stipulated in accordance with 1.2, so long as that application is lodged by the appropriate authority by or on behalf of the person concerned in the manner prescribed by national law. And that preserves, we respectfully submit, the state's discretion to impose requirements relating to the application itself, which may well include a requirement to pay a fee. So there is no proper textual basis for interpreting the language in the manner prescribed by national law as referring only to procedural arrangements for the making and receiving of applications and not to the charging of a fee. And that's particularly so, it might be thought, when it's acknowledged that the charging of a fee is intimately connected to how many a contracting state may fund the procedural arrangements for making and receiving applications for citizenship. So it plainly does not frustrate the object and purpose of the 1961 Convention to do that which is specifically contemplated and permitted by its terms. And to recast the argument as frustration of the object and purpose goes nowhere when that object and purpose is easily discernible from the primary tool of interpretation that the Vienna Convention on the Law of Treaties enjoins you to use, which is to look at the words. Those words do not prohibit the charging of fees. But we also invite you to note that even on the amnesty argument, my learned friend's case is not assisted. And that is because their submission, even on its own terms, only goes as far as to assert that there would be a problem under the 1961 Convention with the imposition of fees at a level above cost. Amnesty then appears to recognise the difficulties that are posed for its arguments by the text of the 1961 Convention, by seeking then to fill the gap through reliance on the other provisions that they seek to rely upon in their other previously unmentioned and unrun articles of the various international conventions. Two in particular they seek to rely upon. The first of them is Article 13, 1.3 of the 1961 Convention. You find that in their authorities bundle at page 489. But as is immediately apparent on looking at that provision, it doesn't advance the argument at all. It's simply a savings clause, the effect of which is that the 1961 Convention is not to be construed so as to disapply any provision which is more conducive to the reduction of statelessness. It doesn't alter or change in any way the express acknowledgement that is inherent in Article 1.1b of the same convention. It's simply a savings clause. Then they seek to rely on Article 32 of the 1954 Convention. That's in the same authorities bundle of electronic 459. But again, the same answer. Nothing that is designed to cut down the permission which is given and the acknowledgement which is inherent in Article 1.1b, which is the lex specialis, if you want to view it in that way, governing fees and dealing with applications in the 1961 Convention. And in any event, as you will see from the terms of Article 32 itself, it is itself subject to and recognises that there may well be charges and costs. And the core point about Article 32 is that there is plainly, and it plainly encloses, a broad margin of discretion at the national level, which is in any event the purport of Article 1.1b of the 1961 Convention. So none of those additional provisions advances the argument in any way, shape or form. But the final point, perhaps, to bear in mind in relation to all of this is that there is no proper basis on which you can attack or seek to attack primary legislation on the basis of inconsistency with an international instrument. That would be fundamentally inconsistent with the basic constitutional principle of dualism, see the Miller litigation. So the only constitutionally proper basis for relying upon international conventions in this context are by way of an aid to interpretation in circumstances where the provision of the primary legislation is ambiguous. That is a proper use of international instruments. But the fundamental rock on which the attempt to rely upon it for that purpose founders is that this argument at its most, as I indicated earlier, goes to assert that setting fees at a level above cost would be problematic from the perspective of those international conventions. We don't accept that, but assume that for the present purpose. The difficulty with that submission is that Parliament has now made it clear in specific and express legislative provisions, first in the 2004 Act and then repeated in the scheme of the 2014 Act, that that is precisely what Parliament has enabled, because it's made specific and express provision for that very purpose.
In short, what you're saying is that cannot attack the primary legislation as unlawful based on dualism. You have to find some ambiguity, and there is none.
there is none. Not merely is there none, but it would be to operate directly against the clear and express will of Parliament.
Yes.
And that's a totally impermissible way of approaching it. But so there are strands of alternative argument. There's the procedural problem. There's a problem at base with their interpretation and approach to the very central provision upon which they rely in international law. And even if they can overcome all of those, they still founder on the dualism rock. So those are the submissions that we make by way of answer to the statelessness point, and that, subject to any further questions you might have, completes my submission.
I see no further questions coming in your direction, Sir James. Thank you very much. Mr. Drabble.
Yes. We had much discussion yesterday about what was the relevant statutory scheme, and I want to make submissions about how to approach that issue as one of the principal parts of the reply. In my submission, it's a mistake to spend time searching for a single scheme. One surprising aspect of my case is that it's based on the provisions of the BNA 1981 and has to accommodate and does accommodate the changes that have taken place since. So I want to, in reply, to indicate precisely how that all works. In answer to a question from Lady Rose yesterday, Sir James said that it was indeed his case that the subsequent changes that follow later in time to the BNA 1981 have swept away any inferences that could be drawn from the BNA itself. One judged the acceptability of the fee by reference to the subsequent provisions and without reference to the BNA. We submit that this is a very unattractive argument and, importantly, is not the result of the application of the language used in the BNA nor in the 2014 Act. And I know I have to grapple with both of those, and so I will do. So let's undertake the exercise. First of all, take a step back and look at what's happening in the BNA. The background is that the BNA is a major constitutional statute. It provides for citizenship, and I'll have a very short word to say in a short while about the principal benefits the citizenship confers. But my learned friend's case expressly and deliberately involves the proposition that central features of the regime established by the BNA 1981 have been fundamentally altered in terms of their practical effect by changes in the fee regime. And in order to make that good, and to explain why that is at the very least a highly unattractive and incorrect approach, I want to concentrate just on a limited number of provisions of the BNA. I do so using these only as examples, so not covering the whole range. I just wanted to see what the consequence in practical terms is of my learned friend's argument. And the provisions are sections 1, subsection 3 of the BNA, section 1, subsection 4 of the BNA, section 3, subsection 2 of the BNA, and paragraph 3 of schedule 2. I go to the latter not for the purpose of taking over or adopting the amnesty argument, it's simply to demonstrate that the consequence of my learned friend's submission is to alter, as time passes, the nature of the response that the UK government has given to the international obligation that lies behind paragraph 3, schedule 2. Now, paragraphs 1, 3 and 1, 4 are important provisions which your lordships and my ladies will find at EF 1308. Go back to those, put them in context. I spent probably too much time on this yesterday, but the context for 1.3 and 1.4 is the basic rule provided in 1.1 that a person born in the United Kingdom after commencement shall be a British citizen at the time of his birth his father or mother is British citizen or settled in the UK. So that's the replacement of jus soli by that requirement to be born in the United Kingdom and to, at the time of the birth, for his father or mother to be a British citizen or settled in the United Kingdom. Now, we know from the parliamentary material and from the white paper that absolute proposition was regarded as true draconian by Parliament. So it's subject to the mitigation that's contained, first of all, in section 1(3). Person born in the United Kingdom after commencement who is not a British citizen shall be entitled to register as a British citizen if, while he is a minor, his father or mother becomes a British citizen or is settled, and an application is made for his registration. So that's mitigation 1. You mitigate the absolute nature of section 1(1) by the ability to make an application for registration, which brings with it the entitlement to be registered, subject to the arguments we're having about fees. But that mitigation is an important part of the scheme. 1(4) we've become more familiar with, is exactly the same point. Assuming that you the child, fail the requirement of 1(1), because your father and mother are not British citizens or settled in the UK, you can still get in under 1(4) on the basis that you've been born in the United Kingdom, but have lived in the United Kingdom for 10 years. Another mitigation of the absolute nature of the rule contained in 1(1). And we've seen from the parliamentary material that that is all designed to reflect what Parliament at the time of the BNA of 1981 thought was a sufficient connection with the United Kingdom. Now, the effect of Sir James's construction of the scheme as he now says it stands is to mean that the content of those two major mitigations have changed radically by the provisions to which I will go in the second part of this reply, hopefully shortly, in particular now in the 2014 Act, with stepping stones on the way in the 2004 Act. I'll look at both of those. Now, it is, we submit, highly unattractive to find the basic shape of a constitutional settlement such as the BNA being altered by a side wind under the fee regime. We haven't seen, we'll look at precisely what the scope of the subject matter that's subject to the fee regime is, various provisions of the fee regime. But we haven't seen any extensive debate about whether it's appropriate to loosen the nature of the ties that you have to have with the United Kingdom to gain membership or anything of that sort. It just doesn't feature. And my learned friend, Sir James's argument, doesn't rely on any such analysis. He simply asserts that you always had to pay a fee, and the machinery is now contained in the 2014 Act. But what you're doing is altering in a very basic way the content of the BNA. Now that issue becomes sharper still if one goes on, just by way of example, these are not exhaustive, to page 1313, electronic page 1313. Sorry, no, I don't mean that, I mean 1315. You look at 3.2. Another mitigation of the basic rule: person born outside the United Kingdom shall be entitled on an application as a British citizen made within the period of 12 months from the date of birth to be registered as such a citizen if the requirements specified in subsections 3, or in the case of a person born stateless, the requirements specified in subsections A and B of that subsections are fulfilled in the case of either that person's mother, father or mother. And then the court can set out in 3 the conditions which relate to the status of the parents at the time of birth. Now, that's a right that's time limited. In order for that to accrue, that specific mitigation of the basic scheme of the BNA to accrue, you must make the application within 12 months from the date of the birth. See the wording of 3.2. So if my learned friend's submission is correct, and assuming that the fee is unaffordable, my learned friends accepts it will be unaffordable to a significant number of people, then you have removed the right. There's no avoiding that. The basic scheme of the mitigation of the rule in the BNA contained in section 3.2 simply cannot operate if the fee is unaffordable within 12 months from the date of the birth. Now that is another demonstration of the way in which this constitutional scheme is being altered by my learned friend's approach to the fee regime. Same point about paragraph 3 of Schedule 2, the statelessness provision. Not concerned to argue about whether amnesty are right or wrong about the International Convention or whatever, but just looking at 3.2, just looking at it as a matter of simple domestic law, what 3.2, sorry, it's paragraph 3 of Schedule 2, I'm sorry, I'm making heavy with it, 3.1 of Schedule 2, what the provision is that a person born in the United Kingdom or British Overseas Territory after commencement shall be entitled on an application for registration under this paragraph to be so registered. The following requirements are satisfied in his case.
Mr. Travel, can you remind me of the electronic page number?
Sorry, my lord, yes, I should have done that. 1347. Apologies. Your lordships and my ladies will recall that amongst the requirements in 3.1b is that you have to be under 22 at the date of the application. So here is a provision enacted to give effect to an international obligation, time limited in the sense that it requires an application by the age of 22, permanently you're under the age of 22. Assuming that it's unaffordable up to that point in time, then once again there's a major change in the manner in which the UK is discharging its international obligation. We say that the court should be extremely slow to approach what I called yesterday the formula, and James kind of like mocking use of me using that, but the formula shall be entitled on an application. It is in Sir James's hands driving a substantial change in the actual way in which the BNA operates. We say the court should be extremely slow to take that route. We have provided this morning, and I don't want to take this to spend much time on this, but just to emphasize the nature of the constitutional settlement that was taking place at the time of the BNA, we've provided chapter 10 of the current edition of Fransman, the leading textbook on nationality law. And without reading any of it, your lordships and my ladies will see paragraph 10.1 just introduces the Act. And therefore goes on through. We have at the top of page 5 is actually in paragraph 10.4.1. Description by the author was the board underlying policy was clear. The 1981 Act would create a new primary category of British nationality, British citizenship, defined in terms of those sufficiently closely connected to the UK itself. The UK distanced itself from pre-1983 CUCKs without a sufficiently close connection to the UK itself, distanced itself from the rest of the Commonwealth. So that's the underlying policy is connection with the Act. I think I meant to draw attention also, just so that your lordships, the court can understand references in the parliamentary material put in to the green paper and white paper. That history is set out in 10.2 on the first page of the clip. Maybe the most useful, maybe the useful way of document that phrase. And then, consistently with the case that I've been advancing about the scheme of the BNA, your lordships and my ladies go to paragraph 10.4.2, journal page 5 of the clip, at the foot of the page. The text says BNA 1981 brought 3 principal changes to the acquisition and loss rules. The first was a move from use towards use sanguinis. Parentage and not just location now determine acquisition by birth. Then second was the eradication of sex discrimination. As far as both birth and descent are concerned, acquisition may be facilitated by a parent of either sex, so on. And then over the page, in the same paragraph, the authors write, the third principal change is what concerned acquisition by registration, the entitlement of British citizens, Commonwealth citizens, including Irish British subjects and Irish citizens, to register under the BNA 1948 had been eroded in the 49 to 82 period. BNA 1981, their transitional period aside, abandoned these entitlements altogether. However, certain new entitlements were introduced. But they are described as entitlements. Those are undoubtedly 1.3, 1.4, etc. Not particularly relying on the description of entitlement. It's just the sense that you're dealing with a major constitutional statute, and here is part of the scheme. So for those reasons, we say, just looking at the BNA, the submissions I made yesterday about the significance of the wording of, say, 1.4 are correct, and that it is not right to see the provision for a fee as driving the content of the right that are created by these various provisions. Now, I then have to go on to make good my submissions about what's happened subsequently being compatible with that view of the BNA. Very one way of doing that, and that is to look at what the provisions actually provide. So if court will look at the SFI, Statement of Facts and Issues, at EF 47, the legislative history is set out, and paragraph 9 introduces section 42 of the 2004 Act, which says it changes the position under the BNA. The court will find section 42 at EF 1299. In my language, tab 1, first authorities bundle, and EF 1299. And this is the first provision that introduces a power to charge in excess of cost. Necessarily, as Lady Rose points out, because of the principle that levying charges without express statutory authority breaches basic constitutional principles, in case McCarthy and Stone and various other provisions of that sort. So 42.1 authorises levying something above cost. 42.2 indicates the provisions to which this applies. And the answer is, for our purposes, section 41, subsection 2 of the BNA. Section 41, subject matter section 41.2 is the whole range of applications for both registration and naturalisation under the BNA. So included within the applications covered in 41.2 will be, for example, applications for an adult in full-time employment to be registered under, say, 1.4, or an application to be registered under the provisions relating to naturalisation. So there's a subject matter for the content for 42.2 to bite on, which is perfectly sensible for there to be provision to raise above cost. That does not mean, I emphatically reject the submission, that means that you can impose unaffordable fees in relation to the provisions of the BNA that we have been discussing, in particular section 1.4. The application, so the provisions of 42.1 are a discretion, not a duty. The Secretary of State doesn't have to act in the way that's authorised by 42.1 in relation to any particular fee. The Secretary of State may, with the consent of the Treasury, impose an amount which is intended to. And the range of matters that are brought in, even under the BNA, encompass a fairly wide range of situations which may involve applications by an adult in full-time employment and so on. So we just don't accept that section 42 has the effect of displacing the submissions that I've already made about the nature of the constitutional settlement under the BNA. So the next step is to go on to the 2014 Act, referred to in paragraph 13 of the SFI. At EF 48. And that refers court to section 68. So it may be sensible to go to the actual text of section 68, which is at EF 1348. If we look at the crucial provisions, which are at page EF 1349, actually. Section 68.8 provides for the maximum. Come back to make submissions on that when we actually look at the order that's made under these provisions. Our basic submission will be there's nothing in the setting of a maximum of £1,500, which indicates that Parliament has authorised, in the primary legislation, the setting of an unaffordable fee for section 1.4. I'll explain how we deal with the issue of the maximum in a moment. 68.9 indicates a list of factors that the Secretary of State may have regard to. The states may have regard only to the factors in 68.9. And our respectful submission is that that cannot mean, and does not mean, that you ignore the character of the right or provision in respect to which you're charging the fee. That will be an absurd submission. On our case, sections 1.4, for example, create a right to be registered on the making of the application. For all the reasons that we discussed yesterday, we'll come back to fairly briefly today, that can't be struck down by the setting of an unaffordable fee. Resubmission 68.9 cannot mean that you ignore, you, the Secretary of State, ignore the basic nature of the statutory provision in respect of which you're setting the fee.
Mr. Drabble, I mean, the Secretary of State's argument against you would emphasise the fact that this is an exclusive list of the circumstances to which the Secretary of State has regard, and you are wanting to imply into the legislation the criterion of affordability. How do you get round the exclusive nature of this provision?
It is, I get round it by saying that it has to be read in a context where the primary legislation, which contains the provision for which you're setting the fee, itself creates a right. So it goes back to Lady Rose's. It's entirely correct that across the whole range of matters, the court, the Secretary of State, has to apply the exclusive list in 68(9), but it does so in a particular context, which will vary from application to application. It's the tail wagging the dog to say that this exclusive list means that the constitutional scheme created by the BNA 1981 is somehow being cut down, is an absurd result of a process of statutory construction. No sign that anyone thought about it at the time. And the exclusive list doesn't fit with the basic scheme of the BNA. And if by that you mean the exclusive list mandates ignoring the nature of the right in respect of which you're setting the fee. Lord Stevens.
Doesn't it specifically exclude affordability? Because the costs of exercising the function may make it unaffordable for some.
No, I don't accept that. You can have regard to, it goes back to the submissions I've already been making about the 2004 Act. You can have regard to the cost of exercising the function, but in a context where you know that the legislation that you're setting the fee for itself creates the right. It doesn't, the fact that you have to think about it doesn't mean that you have to set a fee at a level which reduces the right. If you look, for example, at I made a submission yesterday, not at cost, but as the benefits that the Secretary of State thinks are likely to accrue. He thinks about that in our submission, he or she thinks about that in a context where Parliament in the BNA has said there is an entitlement to registration. So he thinks about the benefit, but where does that take you if the situation is that there is a statutory right created by the BNA, which on the basis of our first set of submissions there is? You don't have to, no particular result of thinking about it is dictated by 68(9). And I mean, I do submit that this is the contrary result would be a startling result. There's no, you've seen the care with which the BNA 1981 was crafted, consideration that went into the provisions that mitigate the basic rule of lex sanguinis. And suddenly they ought to be disappeared, they ought to be rendered nugatory. I use it advisedly because they're picking up on JCWI and Lord Reed in unison. Rendered nugatory by an exclusive construction to 68(9, which ignores the underlying right. That's the point. And we just do not accept that it would be correct for the court to take the step of saying, well, we're driven by 68(9 to say that we can't, Secretary of State can't recognise the basic scheme of the BNA. And then we need, because I'm about to come to the order in just a minute, to move to remember, as well as 68(9, 68(10, which says that in respect of any fee provided for under this section, fee regulations may provide for exceptions, reduction, waiver, or refund of all or part of a fee, etc. So you're looking not to the order, for waivers and so on, but to the subsequent regulations. So just to foreshadow what I shall submit about the order, you have a maximum for applications for registration under the BNA set at £1,500 in the order. That encompasses, as I've already submitted, a whole range of rather different situations. So, for example, applications for registration by an adult in full-time employment. The scheme provides for the ability for the regulations, as well as working within the maximum set by the order, to provide for exceptions, reductions, waivers, and so on. It would obviously be possible within the scheme of this primary legislation to provide for a targeted fee regime which did respect affordability for the class of people with whom my clients, PRCBC, are concerned, whilst giving genuine effect to the maximum for those for whom those concerns are different. We haven't done that. All that's happened is the setting of a fee which is unaffordable, without any waiver, reduction or exception, in a way which distorts the operation of crucial provisions of the BNA. If I could go on to make that good, if we actually look at the order, court will find the order starting at EF 1366. And that provides the most material provision from our point of view is the EF 1384, dealing in regulation 10, table 7 of the order. That sets an order a maximum of 1,500 for naturalisation, and a same maximum for registration of the British citizen, and the other matters don't matter. Really black, really very sorry.
That is then the fee for quite a number of different kinds of applications that we've looked at. So that would, I think, cover both rights and entitlements that you've been drawing to our attention, and also discretionary grants of titles. Would that be right? Is there anywhere which specifies which applications more particularly number 7.1 covers?
I don't think there is. I don't think there is.
Sorry, I think we're dealing actually with 7.2, aren't we?
Well, we're dealing with 7.2. So, I mean, there is the divide between naturalisation and registration, and it's the same figure, but separate maximum established for each of those. So, naturalisation obviously covers a wide range of circumstances and is at the discretion of the Secretary of State in general terms, and will include applications by adults with ample resources, to whom the basic provisions of 68(9) have some sensible meaning. Registration of British citizen is a smaller group of people. It's applications, we need to read the heading, I think. type of application. So type of application is registration as a British citizen. That will include my class, the section 1.4 class, 1.3 class, 3.2 class, paragraph 3 of schedule 2 class, but it will also include the adult applying for registration under, say, 1.4, as we explored yesterday. So there's nothing in the order which is ultra vires. I think the lady asked me at the very relatively early in the case what my case was about the order. We don't complain about the order because a perfectly sensible fee regime respecting our construction of the BNA 1981 could be modelled. Within the maxima, you have the maxima, and then you can provide differently for different categories of individuals, and you can provide for exemptions, waivers, and so on. Startlingly and sharply, the actual regulations don't do that. Now, so those are my submissions on the relationship between the BNA and the regime, the fee setting regime. Now, Learner Friend's submissions yesterday developed an attack on our stance on the basis that we were arguing for a approach to fee setting, which meant that anything under the Immigration Act had to be subject to an affordability criteria. Just don't accept that. The basic line of thought that lies behind Lord Reed in unison in, I think it's paragraphs 103, 104, if I'm remembering the numbers correctly, and JCWI, and Lord Justice Singh in this case in the court below, is that the problem arises where there's a conflict between a right enshrined in primary legislation and the provisions of subordinate legislation providing for, say, a fee, cutting down that right. Now, if one looks at the various provisions of the Immigration Act, sorry, the Immigration Nationality Fees, or the 2016 order that we've been looking at, none of the categories, with the possible exception of with the exception of a subset of provisions in Table 7, relate to rights enshrined in primary legislation. So that if, for example, one looks at the subject matter of Regulation 4, EF 1372, and you look at Table 1, we're dealing with entry clearance. And entry clearance is not the subject of a statutory right enshrined in primary legislation. At the most, it's governed by immigration rules, which aren't even ordinary subordinate legislation. There's a matter of case law about what the status of the immigration rules are. And the court will find in the authorities bundle, Section 1, subsection 4 of the Immigration Act 1971, which sets out what the character of immigration rules are. But there's no issue of any of the subject matter of Table 1 being the subject of a right contained in primary legislation. It just isn't. Exactly the same is true of Table 2, is entry clearance or limited leave as a sponsored worker, etc. Documents in the administration fall into a rather different category, but exactly the same is true of sponsorship. There's statutory right to either be a sponsor or to be sponsored, nothing contained in primary legislation. Exactly the same is true rather more startlingly, in relation to premium services, you don't have a statutory right to have arrangements for expediting the processing or any element of the processing of an application or claim in connection with immigration or nationality. It's just not the sort of subject matter of provisions like the considered in JCWI or effectively in Unity. And so that it's only when you get to table 7, which is the provision we'd be looking at, that we find a subset of 7.2 concerning what I say is in fact on analysis a clear statutory right. Wouldn't apply to naturalisation, which by and large discretionary, and it wouldn't apply to some people applying for registration under the BNA. So my submission, my learned friend submissions for a great part of yesterday about how we were avoiding any control on the subject, on the nature of the rights to which affordability should be seen as the criteria, just miss the target. You have to have a hard look, go back, as it were, to Lord Justice Singh's statement of principle in the present case. You have to look at what the source of the right is. If the right is enshrined in primary legislation, then on the face of it, the dictum of Lord Reid in 103 and 104, and of Lord Justice Simon Brown in JCWI, and indeed of Lord Singh, apply. Now, I fully accept that that's the process of statutory construction. My approach to the statutory construction of the BNA is very, very important for my case, but it is just a matter of construing what Parliament meant when it enacted the BNA in 1981. The answer is that it meant to confer an entitlement which arose as a matter of right on the making of the of the application. So that's my basic submission on the scheme of the BNA and the subsequent development. Just some other very shorter points, important points, shorter points. First of all, my learned friend relies on section 42, 2 and 3 of the BNA 1981 as showing that the making of the application, requirement for an application accompanied by a fee, has exactly the same status under the scheme of the BNA as the right to registration as a citizen itself. That fundamental respect we don't accept, but we invite the court to approach 42, 2 and 3 with the clear thought in mind that any scheme that provides for a fee will have as part of the machinery a sanction for non-payment of the fee, normally refusal to confer the right in question. So 42, 2 and 3 are just the equivalent of the right to the ability to strike out a claim in the industrial tribunal or the employment appeal tribunal that Lord Reid discussed in paragraph 26 of Unison. They don't take us any further than that. Of course you would expect to find a provision that says the right doesn't arise if you don't pay the fee. That doesn't shape the basic structure of the constitutional settlement in the BNA. Second, the next edition is just to submit that citizenship is a very important right. I don't know if a friend says, well, my use of the word important doesn't provide a control. I don't accept that. Citizenship has been described as a right to a bundle of rights. You get a clutch of rights that arise on the basis of the grant of citizenship. Two crucial ones, which are of constitutional importance, are the right of abode, which is the subject matter of Banku. It's important not to lose sight of that. Any ability on the part of the state to defeat your right to reside in the UK is removed the moment you get the right citizenship and therefore the right of abode. And we've seen what Lord Hoffman said about the right of abode in the passage of Banku, which I've quoted already. So you get the right to abode, you also get the right to vote, as my learned friend explained in detail earlier today. We accept that. So you get citizenship, you get two major rights, and you get a whole sense of other advantages. There's a passage in our common skeleton argument in the administrative court, which I would want the court to be aware of, which the court will find at electronic page 360. Wouldn't spend time in reply reading this, but just finds page 360. The skeleton in paragraph 94 summarizes the various evidence that was in front of the court, and we've seen Mr. Justice Day referring to this, about the significance of British citizenship in the sense of a testimony given by a variety of the children involved, and also from various organisations. In paragraph 95, at page EF 361. Now, these are the very effects that we've seen in the parliamentary debates about the BNA, which the provisions of section 1.4 were designed to avoid. This sense of alienation. It's the very effect that 1.4 was on the parliamentary material designed to avoid. And yet it doesn't, by the side wind of my learned friend's reliance on the fee regime. And then in paragraphs 96, we set out the other range of rights that apply, that flow from citizenship: eligibility to apply for a British passport, access to consular support, right to vote in a general election. It's given the court the reference to section 1 of the 1983 Act. Can I just, while we've got this open, I should say that we thought at the time we were arguing in the first instance that paragraph 98 overstated the position. I would invite the court to put a line through paragraph 98. It's not accurate. It overstates the position. But the rest of this whole passage, including the passage on access to secure status and the importance of access to secure status, paragraphs 101 to 104, is important, and we stand by it. Yes, 364 to 365. Well, ladies, these are my submissions, and that's the precise matters on which I can help. Thank you.
What is the current status then of O as a person who has been living here, who is entitled, if they could afford the fee, to be registered, but has not applied for registration? What actual status does she and her parents have?
Yes, I think it's dealt with there's a paragraph in both the Court of Appeal and Mr. Justice Jay's judgment dealing with that. Her mother has limited leave to remain, and she has will have, as I understand it, a parallel limited leave to remain in line with that of her mother.
I see. So she has the same entitlement as her mother does.
Yes. By and large, the leave of the child works in parallel with the leave of the parent.
Stevens.
There are two appellants, and the case that O is making relies upon section 1.4. And so I was wondering whether or not the relief that is being sought is restricted to section 1.4, or if you could assist in relation to what is the relief claimed by the first appellant.
The relief that's sought is aimed at the setting of the fee that we have seen in the fee regulation.
In respect of which section?
Yes.
Are you wishing to follow that up, Lord Stevens?
Well, I was asking what section it was that was in play, the fee, setting the fee in relation to which section of the BNA.
I'd assumed it was section 1.4, but
Yes, I'd assumed it was section 1.4, but I wanted to be absolutely certain because there are two appellants, and O is the appellant about which we have facts.
Here's what some discussion going on in the conference room here, but it is 1.4.
Yeah, thank you very much indeed. That's very kind.
I don't think there are any further questions, so it only remains for me to thank counsel for their careful submissions and to thank those who have assisted them in the preparation for this appeal. This is clearly a matter of some importance and some delicacy, and the court will take time to consider its determination and will produce a judgment as soon as is practicable thereafter. Thank you all very much. Court will now adjourn.